Hey, Joe Zarzaur here to talk about wrongful death cases in the context of a medical malpractice setting in Florida. So wrongful death cases are any personal injury case where somebody passes away as a result of the event. Medical malpractice wrongful death cases are obviously wrongful death cases where the person has died because of an event caused by a healthcare practitioner, and that event precipitates the death. That is a wrongful death medical malpractice case under Florida law. The reason that is significant is that there are special laws that come along with wrongful death cases in the medical malpractice context. And you may ask yourself, why are medical malpractice wrongful death cases treated differently than every other kind of wrongful death case? Well, the hospital lobby and the doctor's lobbies are very powerful lobby interests. And they lobbied the legislature in Florida, in Tallahassee, over the course of 2 or 3 different governors, Republican governors, to decrease the likelihood of lawsuits, they thought. And they thought if they passed more laws, more hurdles, it would make it to where people that were killed and hurt in hospitals, in this context killed in a hospital from medical malpractice, they decided to treat those cases differently than other cases. And here's what they did. They passed some laws limiting what you could recover in a medical malpractice wrongful death case. And here's what the law basically says now. If your family is a victim of medical malpractice and a wrongful death medical malpractice case, the only people that can recover are a surviving spouse and minor children. And they define minor children as anybody under 26. So if you're an adult person and you have a wrongful death in a hospital or medical setting, and you don't have a surviving spouse or minor children, guess what? You don't have a case worthy of pursuit in Florida for wrongful death. And the same is true if you're an older person and you don't have a surviving spouse or minor children. If you die, you don't have a medical malpractice wrongful death case worthy of pursuit in Florida now, because they've basically limited your damages to just your medical and funeral expenses and loss of services. So if there was somebody you were actually supporting, even though you weren't married to them, and it was a lot of support, you theoretically may have a case, but 95% of the cases are done away with now in the medical malpractice setting unless you have a surviving spouse or minor children when you die as a result of the wrongful death medical malpractice case. That is not the law in regards to a wrongful death car wreck or a wrongful death boat accident or a wrongful death, any other kind of negligence, right? You can collect, even if you don't have a surviving spouse or minor children in that context, but if the same thing happens to you, negligence causes your death and it happens to be in a hospital or at the hands of a medical provider, the law is now written to say you can't bring that case. It's another layer of complexity in the medical malpractice wrongful death cases in Florida. It's something that we felt like justified us speaking to. If you have a medical malpractice wrongful death case or a wrongful death case and you need an expert lawyer's consultation for free, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.